All right, so you've decided on arbitration. The question now is, what should your business consider when it is drafting the arbitration agreement? And the first thing that you'll face is making a list of issues that must be resolved with the execution of the arbitration agreement. You know, one of the beautiful parts of arbitration is that we can address all of these issues in our original agreement. We can design the agreement to avoid as many of these issues as we can. So the first thing that we would want to include in an arbitration agreement is deciding whether this is going to be a broad arbitration agreement or a very narrow one. Broad would say any dispute arising out of this contract should be heard in an arbitration. We could narrow that down. We could say any dispute regarding proper delivery of the goods can be heard in arbitration. So we can restrict what it is the arbitrator can hear. We can make a broad agreement that if any party has any dispute, they must bring it in a single arbitration. Or we could have a narrow agreement that allowed for multiple arbitrations involving different aspects of the contract. So the first thing you'd have to decide is, are you going to use a broad or a narrow clause? Obviously, location meaning where is this thing going to be heard? That's huge. Is it going to be in your country? It's going to be in the other country? It's going to be in a third-party country, a neutral country? You want to have those worked out in advance. The language that's going to be used in the arbitration. Remember, you're dealing in an international context. There's no guarantee that that arbitration is going to be heard in English. So therefore, it is important to decide between the parties before executing the agreement in what language will the arbitration be conducted. We'll put in things like notice provisions. What sort of notice provisions do we want? Again, in litigation, these notice provisions are in the rules. They're set out in advance. In an arbitration, we can make the notice provisions whatever we want them to be. We want to say what law is going to apply. And we call this, there's actually two aspects of the law. There's substantive law, which refers to the law that governs the actual dispute. And then there is procedural law, which has to do with how the arbitration is to be conducted. And so that will include things like evidentiary rules or discovery rules. Discovery is the process of obtaining evidence from the other party. So we want to put these into play in advance. I will tell you this, most arbitrations have very few limitations on the type of evidence that can come in. Unlike a jury trial, in which we are concerned about jurors getting tainted by irrelevant evidence, in an arbitration proceeding, we know that our arbitrator already has expertise, and therefore we put it all in there, and we can rely on the arbitrator to sort that out. Of course, we'd want to name our arbitrators, if at all possible, or at least the companies from which the arbitrators will be appointed. So we will include that in our arbitration agreement. Again, we can do this all pre-dispute, before the dispute ever arises. We can settle on a list of procedures, the procedures that will apply to this particular dispute. Confidentiality. If we're concerned about confidentiality, we can provide for things like confidentiality not only of the proceedings, but confidentiality of the award. And we can include negative sanctions if a party violates confidentiality, meaning you could include in the agreement a provision that if the other party violates the confidentiality rules, maybe you don't have to pay. Maybe you can avoid payment of the award. Consolidation of claims, this kind of goes back to that idea of the narrow clause. do we have to include all of the claims in one arbitration, or can we spread them out over multiple arbitrations? Interim measures, meaning can we put into place some idea of things that will happen during the arbitration process. We know it's going to be quicker than litigation, but it's still going to be, there's going to be time involved. And so we can put into place rules about the parties conducting business during the arbitration process. Currency, of course, this is going to be very important to you. What currency is going to be used to pay the award? The cost, who's going to bear the cost of this arbitration? And cost in this case refers to things like the payment for the arbitrators. They're going to get paid, and you have to decide, are you going to split that, or does the loser pay all of those costs? What about the cost of obtaining evidence, or depositions, or court reporters, and any of those events, those costs, we can judge those up front. And of course, we want a provision on finality. I mentioned before that most arbitration are final. We can always include specific language to that effect in terms of the finality of the dispute. Now, there are laws that govern the arbitration process. In the United States, all arbitrations are subject to what's called the Federal Arbitration Act of 1925. And this act established what we call a public policy in favor of arbitration, meaning courts are ordered, they are required to favor arbitration. That if two parties have entered into an arbitration agreement, the court should not interfere with that agreement. And this Federal Arbitration Act has, of course, been, in recent years, been greatly extended, such that this is a reason why we have so many arbitration agreements in the employment context and in the consumer context. Now, there is a model law involving international commercial arbitration. This is prepared by the UN, and it's designed for countries to take that law and enact it into their own legal systems. So this is we're not going to study this, but do know that there's a model law out there, meaning if a party adopts this model law, if a country adopts that law, then another country could adopt it, and therefore the two countries would have the same law governing commercial arbitration. And finally, we get back to that idea of enforceability. It is easier to enforce arbitration awards than court judgments. There is a treaty commonly called the New York Convention. And in this treaty, it sets out that an award issued in a contracting state can be freely enforced in any other contracting state. Meaning that if an arbitration award is made in a country that has adopted the New York Convention, then that arbitration award can be enforced in any other country that has adopted that same treaty, has ratified that same treaty. And at this point in time, virtually every commercial trading country has ratified this treaty. Parties are able to enforce arbitration awards very easily. Virtually every significant commercial country in the world is a party to the New York Convention. In the case of court judgments, unless there is a treaty on recognition of court judgments between the member states where the judgment is rendered and where you seek to enforce it, it may be much more difficult to enforce a court judgment than an arbitration award. So definitely easier to enforce an arbitration award than a court judgment. So in conclusion, what do we learn in this lecture? Dispute resolution in the international context can be difficult. Arbitration is a common means of settling international disputes, and there are a number of considerations that have to be addressed when you choose arbitration. And that's it. Thanks.